It's been updated with some recent changes in the legislation. And as you know, you're all required to do a 4-hour course. So that is a lot of material. We do have a full 4 hours for you. And but do not worry, you will not be quizzed at the end. There's no test. You really just need to try to absorb as much as you can. And what we learned in law school, one of the things they talked to us about is about issue spotting. So it's not that you're going to remember everything that you hear, but you're going to realize where there's an issue. And that's what we do in law, is that we realize, okay, this is an issue, and I need to go back and check my documents or check my statutes, because there's going to be some guidance in those for resolving this issue. So that's what we're going to work on today. Okay, so this is the basics of being a community association board member. 4 hours of basics. We'll try to make it as interesting as we can, hopefully. I really like taking questions. We have a lot of people on Zoom. We've got a number of people in the room, but due to the 4 hours, we'll probably limit the questions throughout the presentation and try to take some at the end. But we will try to pepper in a little bit of questions along the way, because it is a little bit of a long runway of information. Okay, so if you go to the next slide. All right, so we've got our course objectives. What are we trying to accomplish today? We're going to talk about the purpose and duties of the association, the roles and responsibilities of you all as officers and directors. We're going to talk about your governing documents and then the statutes that apply. So every community has a set of governing documents that is unique to that community. And then there are statutes, primarily Chapter 718 that applies to condominiums, and Chapter 720 that will apply to homeowners associations. There are a few other statutes we'll talk about, but those are the two primary ones for associations. We're also going to talk about the roles and responsibilities of the association members. And we'll get into some of the how those roles break down when we talk about your documents. Okay, so starting out, the purpose and duties of the association. So when your community is formed, you have a declaration of condominium or a declaration of covenants in an HOA that is unique to your community. You also have what are called articles of incorporation that incorporate your association as a corporate entity. And if you look at those, sometimes they will lay out the purpose of the association. And what I've come to start telling people is that the association is not guarantors of everything being wonderful in your community all the time. And I think sometimes people overstate the role of the association and kind of give it too much responsibility. And we see that a lot with outside providers like law enforcement. If there's an issue between neighbors, that's not really an association issue, but you'll have law enforcement telling these owners, oh, yo, go to your association, they'll solve that problem. Well, really what your duty is you are operating, managing, and maintaining common property, and you're enforcing covenants. That's all. So what the covenants say that apply to the properties, and then maintaining that common property because it's owned in common by all of the unit owners. So how do we do that? So if we're going to maintain property and enforce covenants, obviously we need a budget, right? All of our expenses for operating the community. We need to establish reserves. This is very critical in condominiums, and we'll talk about some recent changes that I'm sure most of everybody on this call is familiar with the term SERS and Surfside. So those are big events that happened recently. Okay, you have to charge and collect assessments to fund the reserves in your budget. You can enter into contracts. You have to enforce your governing documents. And so we'll talk about a lot of the things with respect to the governing documents. Next slide. Okay, so the association has certain duties and responsibilities under statute, and then we'll talk about the governing documents. But by statute, obviously you're operating, managing, and maintaining your property. You're enforcing the covenants. The association can sue and it can be sued. It can enter into contracts. Obviously, that's important. You can maintain and collect assessments, and you can lien and foreclose for non-payment of assessments. This was even kind of I don't want to say a surprise, but it was interesting to me when I first started working in the condominium and association space. There are very few ways that you can lien and foreclose on somebody's property, but one of those is non-payment of association dues, and it doesn't matter the amount. Okay, access units. A condominium association can access units, not so much in an HOA, and that's because of the way that condominiums are built, and because the units, if something happens in one unit, it can affect other units. Usually in an HOA, you're separated properties, so that's not as big of an issue. Insurance coverage, we're going to talk about that. Maintaining your official records, that's one of your reporting responsibilities to the community, as well as financial reporting. Let's see. Meetings, obviously, those are, so all of those things, records, reporting, meetings, those are a lot of the ways that you are responsible to communicate with the ownership as to what's going on with the board. People ask all the time, well, I didn't know what was going on, or you're not telling us, or these are the ways that you communicate with the community, and it's their responsibility to access those forms of information. Okay, and then we're going to talk about hurricane protection, which was a big issue in the recent legislation. Okay, board of directors, that's you guys. You get to run the show, you get all the benefits, the perks, the big money, right? No. So it is a responsibility to be on a board of directors. You're volunteers, and you give your time and effort to the community. And I know from being on my own HOA board that sometimes it is not a well appreciated job, but it is to the benefit of your community and your property that you're helping to operate the association. So what are the duties of a board member? So you want to act in good faith with diligence, care, and skill. It's important that you care about the community and you prioritize the needs of the community. And you want to promote community involvement, because what we see is that we have board meetings and you're trying to operate your association and issues come up, and there's many ways to solve a problem, but you have to look at the factors that are relevant to your community. The number of owners, how big the problem is, what the solutions are, what is the market for solving problems. Like if you're trying to repair your roof right after a hurricane, you have access to vendor issues. So you have a lot of issues to consider. And oftentimes people come and they're like, you go through all of these things as a board, you look at all this information, and somebody will show up to the 10th meeting that you've talked about this and say, oh no, you're doing everything wrong. Right. And so as a board member, you want to help, educate them on the issues that you're facing, but also promote, well, what is your solution? If you don't like the plan that we're proposing, do you have an alternative? And a lot of times they don't, but you want to, kind of try to foster that involvement within the community. So eligibility, what does it take to be on a board member? You typically have to be a member of the association. That is defined by your bylaws and your articles of incorporation. When the developer forms the entity, your association, and they are on the board, usually it says that you don't need to be a member to be on the board, because obviously the developers are not residents and owners in the community. Sometimes that doesn't change. So we see a lot of documents where that has not changed, and technically you can not be a member of the association and not a resident in the community and still be on the board. However, we would certainly encourage electing board members from among the property owners, because they have the most vested interest in maintaining the property values. Okay, you cannot be delinquent in your monetary obligations to the association. So if you're past due on your assessments, you're not eligible to be on the board. You cannot be a convicted felon, or if you were a convicted felon, you have to have had your rights restored for more than 5 years. This does come up from time to time. Fortunately, not very often, but it has come up. You don't have to be in compliance with all of the covenants. We have had situations where somebody has an architectural violation or some sort of covenant that they're either definitely in violation of or could be in violation of. They're still eligible to be on the board. So being in violation of the covenants typically does not disqualify you from being on the board, just non-payment of assessments and that felony issue. There have been some changes recently in the past year where there could be issues where you're subject to a criminal charge and you would not be eligible to be on the board. And we'll talk about some of these things. It's election violations, fraudulent voting practices, official records violations, things like that could disqualify people from being on board. Okay, so your duty as a board member, you have a fiduciary duty to the owners. And basically what that means is that you are charged with the responsibility of making decisions and allocating money for the benefit of all of the community. So your duty is to act in the interest of the community as a whole, and not to prioritize your interest over others. And as we say, my partner has a saying, a rising tide lifts all boats. So certainly, if you're making decisions in the interest of the community, you live in the community, you own property, you as a board member also benefit from that. That's not an issue. It's when you're acting in your own self-interest that you could run afoul of this fiduciary duty. So, but just so you know, there's a lot of protections for board members because we do occasionally hear people criticizing board members and alleging that they're breaching their fiduciary duty. But you do have insurance coverage, you have the association's obligation to indemnify you, and then you also have the courts, which have stated in order to find a breach of fiduciary duty in the state of Florida, there has to be fraud, self-dealing, and betrayal of trust for you as a board member to be personally liable. So there, certainly in hindsight, we can look at decisions and say, well, that didn't go as well as planned. That's not a breach of fiduciary duty. It's a breach of fiduciary duty if you're commandeering part of the common elements for your own personal use. Let's say you have an accounting practice or some other business and there's an office in the clubhouse and you're like, well, I'm a board member, I'm just going to go in there and use that office every day and run my accounting business out of that. That would be a breach of fiduciary duty.
Sure, you're going to consider this, but isn't there like an E&O or a D&O policy where somebody's individually protected from being sued individually?
Yes, absolutely. So you have director and officer liability insurance, and we're going to talk a little bit more specifically about insurance, but that is a good point. You have the indemnification that the association is going to give you, and then you have director and officer liability insurance. I had some community recently that was like, do we need this? And I'm like, if you don't have it today, go get it right now. Because you're volunteering your time, you're trying to do the best for your community, you need to have that protection. And the association, the community owes that to you. So make sure that you have director and officer liability insurance. Okay, so education requirements. So you guys are familiar with that because you're here. The legislature dropped this on everybody. We kind of saw it coming because there for years has been the option to either take a board certification course like this one or sign a document saying that you've read all of the covenants and you've read the statutes and you agree to abide by all of those. Well, they removed that option this year and made the requirement that all board members, when you're elected or appointed to the board, within 90 days, you have to take this course. And if you're in an HOA, so they have different requirements, HOA and condo. We're not 100% sure why, but if you're in an HOA, it's valid for 4 years of uninterrupted service on the board. If you're in a condo, it's valid for 7 years. In a condo, you need to take a 1 year of continuing education every year as long as you continue your service on the board. If you're in an HOA, you need to take 4 hours a year. In my experience and in our dealings with these associations, condominiums tend to be a little bit more complicated. They're more regulated, so I'm not sure why the HOAs have a 4 hour a year requirement. It's actually 8 hours a year if you have 2,500 or more parcels, which is a pretty significant amount of time for volunteers. We're hoping that they dial back on these requirements at some point, but that is what is required at this point in time. Okay, so conflicts of interest. I'm going to turn that over to Nikki, so you can hear a different voice than mine. But we're going to talk about conflicts of interest and some offenses of directors. There's some existing issues and then some new issues that the legislature added this year.
Good morning, everyone. My name's Nikki Osmer. I'm also a partner at Appleton Rees, and I have been representing community associations possibly for the last 25 years. So I joined Appleton Rees 5 years ago, and it's been a great marriage ever since. Talking about the conflicts of interest for board members, and this has come up a lot lately. The statute provides that if there is a conflict of interest, say for example, you're on the board and your community needs to paint the building. Well, if your brother-in-law owns the painting company, that's a conflict of interest, and you need to disclose that to the board, and you would have to abstain from any voting because of that. So the board members or their relatives entering into contracts, that's a red flag, and they have to disclose that, or an entity in which the board member or their relatives holds an interest in that. The conflict of interest, again, has to be disclosed, and it has to be approved by 2/3 of the non-interested board members, and that's why I'm saying you need to abstain from that vote. Kickbacks. These have come up quite a bit because they're finding ways around to provide gifts. And you got to be really, really careful about that because it could be seen as a conflict for board members as well. Say, for example, you get something from a painting company or a landscaping company or anything like that. There are certain monetary values on that that you cannot exceed. But board members and managers should not knowingly accept any kickbacks, cash, gifts, tickets to the football game, whatever it may be. And there are also criminal charges that could be associated with any conflict of interest against that board member. Remember, you're dealing with money that's not yours. And the way that you spend that money is going to be scrutinized, as you know, board members. So ensure that if there is a conflict of interest or you think there may be one, disclose it. Next slide. Okay, so another issue, and this comes up too, if you have several properties that are delinquent on assessments and you've hired a law firm to do collections on your assessments, board members and their managers are not permitted to bid on those foreclosure sales. They can't purchase those properties. It's kind of like you're an insider, and the insiders have this information and they know how much is worth, and it is a conflict of interest as well. And how it applies specifically to managers, the disclosures are that the association proposes to enter into a contract with the management company, and the management company or any director, officer, or employee of their relative has a financial interest. So same way it's on the board side, it's also on the management side. So if you have any familiarity or a type of relationship, family relationship, stay away from that. Additionally, the disclosures for conflicts of potential interest, they have to be on the board meeting agenda, and they also have to be reflected in the minutes. How else are you going to prove that this board member abstained from voting and actually disclose the potential conflict of interest? There's no way to solidify that or have any evidence of it. Your meeting minutes are very important, and some boards who maybe self-managed or they've had over the years not kept their records pursuant to the statute. If you're faced with a lawsuit in the future, our job is to go through those board meeting minutes to see what actually happened. And we're going to get more into that, but this is a way that you need to disclose that, and it needs to be reflected in the minutes as well. You also need to obtain competitive bids. So don't just show up with one proposal and you may have a financial interest in it. Obviously, there's statutes that provide that if your services or the projects are over a certain amount, you need to get bids. There's also disciplinary actions for failing to disclose, and that could be detrimental to your license as a manager. So make sure that you disclose if you think there's a possibility, because the contract, if it's entered into, it can be voided. Fraudulent voting activities. This is actually a first-degree misdemeanor, and these charges came out a few years ago because there was a lot of voting fraud going on. So the definition is if you willfully and falsely swearing to or affirming an oath or affirmation, or if you willingly procuring another person to falsely swear to affirm, that's fraud. Okay, so be very careful. I know a lot of the owners go out there and they start to petition and go to homeowners' houses door to door, trying to get the current board off, okay? I have experience where there's a certain group of homeowners, and they will actually commit fraud, and they will possibly go into an elderly homeowner who maybe has dementia or has some sort of a mental impairment. And they get them to sign these recall ballots or voting ballots because they want the current board to get off. Can't do that. And I actually had a situation like that a few months ago. There was a board on a condo association, and they were trying to recall the current board, and there were two owners that they had signed. And I actually reached out to the daughter and I said, "Did your father sign this? Did he know what he was signing?" And she said, "No, absolutely not. I take care of all his business." If you try to attempt or perpetrate in aiding of the preparation of fraud in connection with any vote, you're also going to be charged with a misdemeanor. Also, if you prevent a homeowner from casting their vote the way they want, or if you doctor the votes later on, also considered a misdemeanor. Next slide. Again, giving or promising directly or indirectly, kickbacks. Hey, let me give you these tickets. Can you sign this recall ballot or sign this proxy or ballot? Okay, again, kickbacks. This excludes, though, food served at an election rally or meeting or any item of nominal value which is used as an election advertisement, including a campaign message designed to be worn by a member. And why would that be? Because it's for the entire community. It's not one-on-one, and you're not committing that fraud individually. Again, if you aid and abet in the commission of a fraudulent activity, also agreeing and conspiring or confederating with at least one other person to commit fraudulent voting, or having any knowledge of a fraudulent voting activity and giving any aid to the offender. So you may not have started it, but if you helped, could be found guilty of a misdemeanor. Next slide. Okay, strategic lawsuits against public participation. These are considered SLAPP suits. And I know everyone has experienced a homeowner who's been a problem in the past. They're very disrespectful. They are misrepresenting the truth. They may be slandering your good name, accusing you of stealing money from the association. Every board member comes to us and says, "Why can't we sue them? Why can't we make them be quiet?" And this is why. So where a unit owner exercises the right to instruct their representatives or the right to petition for redress of grievances before a condominium association or various governmental entities of the state as protected by the First Amendment. So first of all, you cannot file any lawsuits which have no merit, okay? And secondly, you could be fined or discriminatorily increase a unit owner's assessments or decrease services to a unit owner because of this. So what if the board says, well, they can't use the amenities because they won't stop talking bad about the board? Can't do that, okay? So all of the homeowners have a right under the First Amendment to voice their opinions, and by the board trying to silence that person, it's the same as politics, okay? So you can't retaliate against homeowners because they're speaking their mind and they may have an interest in what's going on with the association and they're publicizing it. Now, obviously, if it's a lie or they're embellishing or they don't have the proper facts, that's a different story. But again, under the new law, you cannot just file a lawsuit or take away someone's rights because you don't like the way that they're acting towards the board. Next slide. Roles and responsibilities of directors and officers. Go ahead, Michelle.
There you go. Don't sue any of your owners. And just to back up a little bit, just be cautious about those things. I mean, some of these things can happen very innocently. You know, somebody's having trouble writing and they want you to help them with their ballot. They ask you questions about how to fill out the proxy form. Just be very diplomatic and again, issue spotting. Be careful that you don't change anybody's ballot, even in an innocent way, that you hands off and let maybe the manager handle it or something else. And then the strategic lawsuits against public participation, that was a new one that they kind of expanded in the recent legislation. And we do see it a little bit, like, you know, somebody's coming to the meetings and they're complaining all the time and they're like, all right, well, now we're going to finally hit him with a violation for that truck he's had parked in the wrong place for a long time. No can do, right? Okay, so roles and responsibilities of directors and officers. Okay, so we're going to talk about the roles of the directors and officers on the board versus management. And we call this the stay in your lane slide because you guys have responsibilities as board, but if you hired a management company, you have a contract with that management company, you're paying them to provide a service, and you should let them do that. We occasionally, sometimes more than occasionally, we'll hear board members saying, oh my gosh, this is a full-time job. I'm doing board work, 40 hours a week. Literally hear this. And I'm like, that's wrong. That if you're spending 40 hours a week on board business, you're doing something wrong. You need to pull out your management contract and say, where am I stepping into what that manager is supposed to be doing? And the managers don't want you stepping into their lane because that's what they're good at. That's what they've been hired to do. And they're there to help you, and they have, good expertise in that area. Okay, so roles of the board. So you need to understand and enforce your governing documents, represent your owners. You're setting policies and goals. So you're setting, what are the important issues in my community, and and then you send your manager out to help you accomplish those goals. So if the landscaping has not been looking great, you send them out to find new landscapers, new proposals for updating the plants. If you have roof issues, you send them out to find the roofers, and then they come back to you with the bids, and help you decide on which one to pick. But it's your decision on which contract you go with. They're just going to give you that information. They're going to do the legwork, and then you're going to make those higher level decisions for the community. So you're making the decisions about business. You can adopt rules. Obviously, you're conducting meetings. And your goal is really maintaining your property values, making sure that your association is financially stable so that you can continue, again, operating and maintaining that common property and in maintaining your property value. And I explained this recently and when we talk about the governing documents, we'll talk about this a little bit more. When the developer forms your association and you buy into that association, really what an association is doing, especially in a homeowner's context, is you're all agreeing that you're going to hold your property to a little bit higher of a standard than what the city or the government would be doing for you. And so you keep that in mind in your role as a board, that what is our community standard? What are we keeping our community to? And then your manager obviously is going to help you carry out your goals, policies, decisions. They'll give you feedback. Obviously, they should be your center point of communication. There should be the manager is a buffer between you as the board and the owners. So if the owners have complaints, if they have issues, if they have concerns, send it to the manager. And the manager will let us know, and then the board can review those issues at a board meeting. We have communities where, you know, the board members are in direct contact with the owners, which is fine. Obviously, they're your neighbors. You're going to be in direct contact with them, understandably. But when it comes to dealing with issues about problems in the community, they're having issues with their neighbor, they got a violation notice, they're behind on assessments. Those issues you want to funnel through management, again, because that's going to take a lot of your time if you are the first line of defense on those issues. And it also can be it can be a little difficult because they are your neighbors. And so having that layer between you and them can be very helpful for, you know, a more comfortable living situation. So to put it one way. Okay, so directors and officers. So we'll talk about the officer positions. You've got your president, vice president, secretary, and treasurer. They have different roles, but they're all equal. The president does not have a more weighted vote than anybody else. They do not get paid more. It is all equal in terms of their role on the board. This is just a division of responsibilities. So your president is usually the first point of contact for all of your contractors. You can change that, but they tend to be the point of contact with management, with legal, with accounting, landscaping, all of those folks. But if you would like, you can obviously make the treasurer the point of contact with accounting if you want to do that. But they are the default typically. They're going to conduct the meetings. They're going to decide what goes on the agenda, obviously with input from the other board members, but they help to do that, to schedule the meetings, and then chair and conduct the meetings. Obviously they sign off on things like amendments, contracts, things like that. Not that you can't have other people, but they're the default. Vice president will serve in the stead of the president. Not too much to say on that one. Vice president's just like in our government, it has the same sort of importantness to it. So secretary, I'm moving on from my political commentary. We'll talk about the secretary. So secretary, I call them the holder of the paper. Typically, if you have a management company, like you have invested as your management company, they will handle a lot of the responsibilities of what the secretary will do. They will maintain your official records for you. They will send out your meeting notices. What else? They'll help do all the mailings. They will maintain voting records, things like that. As the secretary, though, if that is your role on the board, you want to be in contact with your manager so that you know things like, where are your official records? What is contained in those official records? Is my manager responding to those official record requests in a timely manner? Do I have a policy for responding to records requests? Because we'll talk about that in a little bit. That is one of your reporting duties to your owners, is providing records upon request. You're a closed corporation of members, but the members have access to all of the records in the association. And we'll get into that a little bit more. Okay, treasurer, similar to secretary. Again, a lot of these duties and responsibilities are assumed by your management company. They will send out your assessment notices. They will assist you with preparing the budget. You are the final decision maker on the budget, though. They present it to you, and then you can suggest changes, and you are the ones that have to adopt that budget. But they will assist you in doing that. They'll help maintain your bank accounts, pay your invoices. So what does the treasurer do? The treasurer works with management. You want to look at your budgets. You want to look at those financial reports that they give you to make sure are our invoices getting paid on time? Are we on track with our budget? Are we overspending in any line items? Do we need to look at that? When we're approving projects, do we have money for that? Where is that money? What do we have in reserves? Critically, where are our bank accounts? We have communities where the members don't know what bank they have, don't know how much is in their bank account. That would be something the treasurer wants to be keyed into. Do we have, is Truist our bank? Is it Chase? Where do we have it? And how much is in there? Do we have one account? Do we have 4 accounts? So that's pretty much it on the treasurer. Okay, and I talked about the manager. They're, they will attend your meetings. They will help coordinate them. A lot of times they'll take minutes, or they'll keep the minutes for you. But their main role is to act out your directives, right? What do we need to do in the community? Do we have a wall that needs to be repaired? Are roads failing? Do we need insurance? Is it time to update our insurance? And please go out and get us bids and bring them back so that we can decide what's in the best interest of our community. And they have a lot of information. They are a great resource. They, they manage, each manager manages many communities, and then they have obviously other managers in their company. So they have a wide breadth of information that they can help you with. They know the reputations of various contractors. They know how to solve different types of problems that crop up in communities from time to time. So a great resource. Do you guys want to add it? Any Vesta managers want to add anything about the role of manager?
You hit the nail on the head.
Okay, good. Division of Condominiums Oversight. So the Division of Condominiums typically used to only get involved mostly in elections, but they have expanded their role in the recent legislation. We'll see how this plays out, but they do have jurisdiction to enforce compliance with all of these elements here. Payment of assessments, financial records, use of debit cards. That was a hot issue in the recent legislation. Don't use debit cards. Elections recalls, electronic voting, maintaining official records and providing official records, the structural integrity reserve study, making sure that's done on time. Folks are in compliance with that. And they have some enforcement mechanisms, including referring people to law enforcement. But so they've expanded their role, and we'll kind of see how that plays out over the next couple of years. Okay, so I'm going to turn it back to Nikki to talk to you about the governing documents. So we talked about statutes. Now we're going to talk about your unique governing documents.
Okay. Governing document. Everybody knows the Declaration. So it is the constitution of your association. And what that means is that you're going to have all of your regulations and restrictions contained in the Declaration. Additionally, the Declaration is going to define property ownership. So you'll know if there's easements anywhere, what the common property consists of, and what the units consist of as far as the plat is concerned, and who owns what, who maintains what. There's always issues, especially when you're in a condo association. Does the association have a duty to repair my air conditioning? Or does the Declaration say that unit owners are responsible for their air conditioning? It depends. Every community is different, and your declaration is going to be tailored for your community. Additionally, it also provides what the rights and responsibilities are of the association. For example, assessments and lien rights. How are we to pay expenses if you're not collecting assessments? And I see this as a problem sometime with board members wanting to push the envelope because they don't want to sue their neighbor or their friend or what have you. But remember, as board members, you have a fiduciary duty, okay, to collect those assessments and to comply with the governing documents of the association. So if you're not doing that, you're in violation of your fiduciary duties. Additionally, it's going to talk about insurance. There may be some additional insurance that's needed, or you have a unique property that maybe has a horse trail, or you have tennis courts or golf course or anything like that. So talk to your insurance agents and make sure that you are appropriately covered. Unfortunately, the insurance rates have skyrocketed, doubled and tripled, particularly for the condo associations, and we'll get into that later. But it was based basically on the collapse of Surfside down in Miami Beach. And then amendments. You're always going to have an amendment section. It's very rare that you're not going to have an amendment section in your declaration, and that's going to tell you how you need to, what type of votes you need. How much do you need from the board? How many votes do you need from the members? And you can make those amendments, but you have to follow the procedures to do that. And then you're going to be recording the certificate of amendment where an officer is actually signing it saying, we follow the declaration, we obtain 2/3 of the membership vote to approve this amendment, and then it becomes part of the declaration. So the Articles of Incorporation is actually filed first. This is what actually creates the association. And remember that the association is a corporation. It's a not-for-profit corporation, and the applicable statute for that is 617. So in addition to having 718 or 720, you also have the powers of a not-for-profit corporation. And we went into that a little bit earlier, where you can be sued, you can sue, things of that nature. The bylaws. So the bylaws are kind of the guidebook for the board of directors, because it will contain your term limits, how your elections should be conducted, anything relating to the budget. You may see that in the declaration, but you will see financials in there as well. How are your elections to be conducted? And who are the officers? How many officers do you have? How many directors are you supposed to have? And remember that if your bylaws say you have to have 5 board members, but you only have 3, you need to get 2 more people, because the bylaws require that you have 5, okay? So the bylaws are also going to put the members' voting rights in there as well. And it will also address records of the association. You may have some sort of a maintenance agreement that comes in, or you may have a master association with different requirements. Next slide. The rules and regulations. So I always say this is the bottom of the food chain, because you have an hierarchy of documents for statute, declaration, articles, bylaws, and then on the very bottom is the rules and regulations. Why? Because you don't need to have a membership vote to pass rules and regulations. As long as the declaration states the board of directors has the power to implement reasonable rules and regulations regarding the common areas. Okay, that's the common areas, but you have to be very careful, because if the declaration does not provide that the board has authority to pass rules and regulations regarding the use of a lot or use of a condo, you can't pass any rules that would affect someone's property rights that way, okay? Because you don't have the authority. The way to change that would be through an amendment, okay? But again, you're gonna have to follow the amendment procedures in the declaration regarding percentages of the approval. If that's too hard to do, then you should probably tackle that first in an amendment before you start to change everything. It may be a moot point, and you're going to be spending money on attorney's fees to make an amendment if you're not going to get participation. So let's also talk about limitations on the enforceability of architectural covenants. And this is fairly new as well, but and all the lawyers were up in arms when this came out. I know I was. So we have a huge case right now that we're litigating on this very issue. But the association right now, they cannot prohibit any owners from storing their personal property on their lot, including RVs. If you have a homeowner that has an RV, they can park it on their lot as long as you cannot see it from neighbor or the street. So good luck doing that, because that's a big piece of equipment that you're trying to hide, okay? But the association is also not required, may not require approval of plans and specifications for central air conditioning, refrigeration, heating, or ventilation systems, which are not visible from the parcel's frontage or an adjacent parcel, as I just mentioned. Also, upon denying any architectural applications, the association must provide written notice to the owner stating with specificity what the rule is. So if you're sending out violations, or if you're sending a denial letter, you have to put a specific reason why. And if you're citing to something in the declaration, let's say, for example, you're in a condo and one of the unit owners is drilling through the concrete slab, you have to tell the homeowner, hello, you cannot cut into the slab. That's common area. It's going to affect the support of the building, okay? Also with aspects of the proposed improvements which does not conform. So again, you can't just do a blanket denial. You have to say why you're denying the application. Next slide. Okay. Oh, vehicles and contractors. So again, the governing documents cannot prohibit storage of any personal property, including personal vehicles or pickup trucks in the owner's driveway, okay? Or any other area where the owner or guest has the right to park pursuant to local law. So there's a lot of declarations out there that say you can't have a commercial vehicle on site, right? Lettering and all that stuff. Well, that's somebody's work vehicle. So the law has changed in reference to that. I remember also a couple of years ago, there was a board that actually sent a violation letter to a police officer for parking his cruiser in his driveway. So that was a huge piece of the news, and I was like, oh, that's dumb. And you also have to exclude from the commercial vehicles that's defined under Florida statute. And there's the definition. You know, it has a gross weight of 26,001 pounds. Okay. And or has 3 or more axles, regardless of the weight, or is used in combination with the weight of such combination which exceeds to 26,000 pounds. Again, first responders or police officers, they're exempt. You cannot enforce any of those regulations, obviously. And the association governing documents may prohibit an owner from inviting, hiring, or allowing entry of a contractor or worker on his or her parcel solely because the contractor or the worker does not have a professional or occupational license, okay? And I actually had a board member who prevented a contractor from coming onto the condominium property because the owner had not filled out an ACC. And I said, whoa, don't do that. Let's do things the right way. But, you know, you can't just take matters into your own hands. Be very, very careful. When in doubt, check your declarations, check your bylaws, see if the board has the authority to do what it is that they're doing. And if you don't know, pick up the phone and call your lawyer. That's a 15-minute call. Instead of spending 15 minutes for a couple $100 to get the interpretation correct, don't get involved in litigation 2 years from now with a homeowner that's going to cost the associations hundreds of thousands of dollars. Okay, Michelle's going to take over for the hurricane protection.
And just to back up on the vehicle issues, I know this is really critical to a lot of communities. They've been very concerned about the fact that the legislature stepped in and said that we can't enforce things about parking commercial vehicles in driveways, parking on streets and things like that. There's a lot of concern, as Nikki mentioned, among the lawyers that there's your declaration of covenants and your declaration of condominium. It's a contract among all of the owners. And there's a rule in law that the legislature can't really interfere with a private contract unless there's some superseding state interest. And we really don't see that here. So we're, looking to see how this plays out. We're cautious about, recommending to associations to violate the statute because we don't want you to be the test case in litigation on this issue. Because it is going to be, could be very expensive. So we're trying to walk the line right now of complying as much as you can with your covenants and also not violating this new statute. But just know that there is a lot of attention on these changes. I know that they're very controversial, but we're hoping that while I don't recommend any of my clients to be the test case, there will be test cases out there. And there are associations that are going to take on that issue. And so we're going to see how that plays out over the next year or so. And we'll keep you updated. But if you have issues with these things where the statute's conflicting with your documents, you need to talk to your lawyer about how to walk that line of enforcement. It may be that you just send the violation notice, but that you don't take any further enforcement action. It may be that you hold all of those things in abeyance for a little while and then do a refresh letter if things change in the statute. So But anyway, so moving on from that to hurricane protection, this was another hot topic in the legislation. So now condominium associations and homeowners associations are supposed to adopt hurricane protection standards that are consistent with your code. How do you do that? There's not a lot of guidance. We have suggested that you consult with an engineer to create those specifications and make sure that they are compliant with the building code. But there are things like hurricane shutters, impact resistant glass, code compliant windows and doors, roofing systems, not so much in a condominium, but in a homeowners association, roofing systems and things that you can use that are hurricane protection specific. We have actually had an engineer talk to us about these issues, and I actually didn't know this, but they're leaning away from hurricane shutters. Apparently they're not any more effective than hurricane protective windows. And so if you in your community wanted to, make specifications that says that, we're going to permit hurricane protective resistant windows and glass, but we're going to limit shutters, you could do that. Now, if you don't have those specifications, it would be much harder for you to limit those things when folks wanted to install them. So if that's important to you as a community, and it's important to the legislation, they do want you to adopt those specifications. You can control things like the color and the style, the type of hurricane protection. They're now having in your condominium declarations, if it's not already there, that they will in the future provide for who's going to install, maintain, and repair that hurricane protection in a condominium. Installing hurricane protection in a condominium is not a material alteration. So you don't need a vote of the owners if that is part of your specifications. Next slide. And there are provisions that they added that allow the association to vote in a condominium, not an HOA. In a condominium, they allow the association and the owners to vote to require installation of certain hurricane protection. And so if you have that vote and it's voted in favor, it would specify who would be responsible for doing that, the cost, and then that would get recorded actually in the public records with the due date for meeting that compliance. A lot of newer condominiums, as far as I've come to understand recently, already have hurricane protective windows and glass and things like that. So this is probably more applicable to those older condominium buildings. And then what else? So your unit owners aren't responsible for the cost of removal and reinstallation of hurricane protection if necessary for maintenance of association property. So if the association is responsible for, let's say, the balconies, and in order to do some maintenance on the balconies, you've got to remove those hurricane shutters. That would be all part of the cost of the project. And you couldn't require the owner to pay for that. And actually I had a situation just like that when the law changed. And they were like, well, who's going to take the hurricane shutters off and put them back up while we're fixing the balconies? And initially, per the documents, it looked like it was an owner responsibility. And then the statute came out and we're like, okay, well, this is part of the project. Okay, so next slide. Okay, and then hurricane protection in a homeowners association. You are, as an HOA, supposed to adopt code compliant hurricane protection specifications. It's not worded as an option, it's worded as a requirement. So that would be for not only your clubhouse and your buildings that are operated and maintained by the association, but also within the community, what hurricane compliant protection would you like permitted? Again, is it the windows and glass? Are there any specifications with respect to roofs? Are you going to permit hurricane shutters? Are there colors, styles, things like that you want to limit? Other things, garage doors. There's even things like erosion control, generators. Oh God, generators. I had so many issues with generators, like all at once, right around the hurricane time. Where can they put it? What is making too much noise? Can it go in the common elements? How long can they have it out? Those are things that you might want to look at in the future and add those to your hurricane protection specifications if it could be an issue in your community. So they can be as broad as you need them to be, but you are supposed to adopt some version of hurricane protection specifications. Okay. My Safe Florida condominium program, obviously this is only for our condominium association board members. The legislature adopted, and it actually was an existing program, they expanded to permit associations to apply for funding for hurricane mitigation measures. So you could apply for funding for a study to recommend improvements, and then you could get funding for actually installing those recommended improvements. It was $2 for every $1 that the association funded for the hurricane protection, up to, I want to say it was $175,000. This is a little historical because this came out, the legislation only came out in July. The program opened up at some point last fall, and all the money is gone. So they're looking at refunding it for next year. But it is a good program, and it is something to apply for, especially if you want to get information as to what types of hurricane protection might be a good idea for your condominium. So that's out there. Does anybody have any questions or any issues that I missed? We can take a little question break, because I know we've both been talking for a while, and we've covered a lot of ground.
So what I heard on the work vehicles is we can't enforce it, so they can park the vehicle there, correct?
That is the current status right now because of the statute. And like I said, it is our position as lawyers that conflicts with your documents, and that's a little bit of overreach into the role of the legislature versus your declaration, which is your contract among your community members. But we don't want you to be the test case to take that to court and incur that cost. So we're just going to monitor it for now.
We have a test case in my neighborhood. I'll keep you informed on it.
Oh, good.
Well, Villa Rosa, there's some guy in the neighborhood with a Sprinter van, and
Okay.
the board's calling it a mobile home or something or other. And it's been going on for almost a year. We're like 30, 40 grand legal fees into it.
Yeah.
I'm going to the next board meeting going, I don't know what direction we're gonna go, but we're done paying dues on it. But there's gotta be a deadline to figure this out. If somebody wanted to push the limits, just like you're saying, and
Yeah,
once
you go to court in a violation matter, those costs can, as you've seen, they can escalate pretty quickly. So my goal and our goal is really to try to help the board avoid litigation. And we're going to talk about some of those things coming up, but it can be very expensive. So, the legislature put us in a little bit of a conundrum right now with respect to those work vehicles and the vehicles in the driveway. But we're going to see how other people deal with it, and hopefully there will be some changes down the road. But yeah, for right now, you probably want to hold off on doing any enforcement on those vehicles in the driveway, unless you're willing to put your money forward and be that test case. I mean, we'll all be watching. We're excited to see how it goes. Any other topic areas that?
I've got one here from online. We have owners parking boats, etc., that are visible from the street neighbors. How do we deal with this, since we can't have CNR restrictions, any enforcement avenues under 720?
So as Nikki mentioned, if you have an RV or a boat or something, you can store it in the backyard, but it cannot be visible from the parcel frontage or from common area or adjacent parcels. And so when you're talking about big vehicles like that, that is a little tricky. They cannot be parked in the driveway. The permission on allowing vehicles in the driveway, in my read of the new legislation, would not include boats and RVs. So if you have restrictions in your documents that prohibit parking an RV in the driveway, in my read of it, you can still enforce that. Now, if they move it to the backyard and it's somehow, not visible because they've got landscaping and they've got fences, that's fine. The legislature kind of stops your jurisdiction at that fence line. And so the backyard is not really your realm to control, even if your documents permitted that, unless you can see it. Which in a lot of communities, if you have two-story houses, or you have golf courses behind lots or common areas, I don't know how your backyard is not visible to either an adjacent parcel or a common area, but if it is in fact not visible, like if somebody has like, artificial turf in their backyard, they want to build themselves a little mini golf course in the back, and you really can't see it, that is not for the board to regulate and the association. Good, good. Okay, all right. Well, I'm gonna let Nikki talk a little bit about some board meetings, and then we'll talk about the membership meetings and elections.
Okay, so board meeting. Remember that this is a board meeting. It's not a membership meeting, okay? And you're here to conduct business of the association through the board meetings, okay? And this is how the owners are made aware of issues that are going on in the association, what projects are going on, things of that nature. When you're having a quorum of the board, you're having a meeting, which requires you to post notice of that meeting because you're discussing association business. Please, please, please do not make a vote or carry on some sort of action without posting notice of a board meeting and taking a board vote, okay? There's an exception for emergencies, okay, but you have to be careful because some people are saying, well, this is an emergency. No, it's not. If we are in a state of emergency declared by the governor, then yes, hurricanes come in. We have crazy weather coming that we need to prepare for. If you have to do things electronically, or if you have to make calls that are going to endanger other units or homes, then there's those emergency powers, okay? If you're ever in a situation where you have to make a decision right there and then, and you don't have time for a board meeting, you have to ratify that decision in your board meeting, and it should be reflected in the minutes. Again, minutes are how we know what happened at the meeting and what authority or what votes the board took on the business of the association, okay? It also includes architectural review and finding committee meetings. And in fact, it's all committee meetings involving a final decision regarding expenditures of association money. What the board meetings exclude are meetings with the attorney, if you're going to be discussing litigation, any personnel issues, if you're discussing employees of the association, salaries, your applications, maybe a homeowner has requested a reasonable accommodation for disability and they have a dog that they want to bring into a no pet community. You're going to be exposed to medical records and diagnoses from their doctor. So those as well are not to be discussed at an open board meeting. Members can always attend unless you're meeting with the attorney or you're discussing those confidential issues. And you have to stick to the agenda items. So I know there's going to be members out there that want to talk about this and talk about that, but if it's not on the agenda, they can't talk about it. And that goes for the board as well. If it's not on the agenda, don't discuss it. So make sure that you are prepared for your meeting and that you put on the agenda everything that you're going to be speaking about, whether or not you're going to be inviting a guest, your insurance agent, your lawyer, whoever it is. That needs to be maintained in the notice so that everyone understands and knows what business is being discussed at that meeting, okay? For condo associations, you have to at least meet quarterly, and you have to permit owners to ask questions of the board 4 times a year. And those are on issues affecting the condo construction, repair projects, revenues, and expenses for the current year. Notice of your board meetings. Remember, you only need to post 48 hours notice for a regular board meeting, okay? There are other standards which require additional days of notice. One of those would be if you're considering a special assessment or you're amending your governing documents. So you have to at least send notice 14 days prior. In meetings at which assessments shall be considered, you have to disclose in the notice what the estimate costs are and what the purpose of the special assessment is. So if you have multiple projects that are going on in the community, you got to list those all. Okay, what is it going to cost? What are you allocating the funds for, and what's the total that's going to be assessed? So that has to be in your notice. You also have to simultaneously, when you post notice, agenda and contracts, let's say, for example, that you are voting to approve an amendment that's going to go to the members. You should include that amendment in your notice, okay? In other documentation as well. For example, if you are approving the budget, you have to provide a copy of the proposed budget that the board is going to be voting on to approve at that board meeting. And again, 14 days notice for that. Under Florida Statute 718 and 720, the declaration and bylaws will provide some information regarding the notice requirements. But again, your documents were drafted by the Developers Council probably decades ago, okay? So some of your notice requirements or whatever it is in your documents, unfortunately, if you have a more stringent requirement in the declaration, for example, if your bylaws say you have to provide 30 days notice prior to a budget meeting, you need to provide 30 days notice, not the 14 under the statute. And we always caution our clients to say, just go with the higher standard so that there won't be any issues if somebody contests it. Next slide. Okay, plan your board meetings. This is important. These board meetings should not go on for hours. You have your agenda, stick to your agenda items, and move along. I've attended board meetings that over 3 hours long sometimes. I mean, crazy. You guys want to pay your lawyer to sit there for 3 hours? That's great. But it has to be structured, okay? And remember that this is a board meeting. So the members are not making a decision. It is a board meeting. You guys are making the decisions, okay? So you got to define the purpose of the meeting. Remember, you have to have an agenda. You have to disclose the date, time, and location of the meeting. You're going to review your minutes from the last meeting. Normally you'll have the treasurer's report, which will detail the funds that are in the bank account, what are the delinquencies, what's going on with the finances, whatever issue it is that you're addressing at that board meeting. Committee meetings reports. You're also going to review that if there is a committee. Let's say, for example, you have a fining committee and they're bringing their report to the board, or you could have any other committee that the board would create for a certain purpose. So you would get your reports from the committee as updates if they need assistance from the board, or if they're going to make a decision, if they have that power. You also want to do your action items. Are we trying to approve an amendment? Are we approving the budget? And then also new business to consider. So what are we planning in the future, or what are we going to be talking about today that's new that we haven't discussed in the past? Again, you have to identify your documents and your contracts, and you invite your appropriate people and provide them with notice. Again, if you have a legal issue in the community, or if you have an amendment and the homeowners are just lost, they just don't understand, in your notice say, the attorney will be here to explain the amendment and you may ask any questions, things like that. Next slide. Okay, let's switch gears. We're talking about membership meetings now. Okay, this is for the homeowners and the unit owners. There are two types of meetings. You have your annual meeting where elections take place, and you also have special meetings. Your special meetings can be held anytime. And you don't have to put proposals in front of the membership at the annual meeting. So let's say, for example, that you want to change the bylaws so that you can have 2-year staggered terms, okay? If you're going to do that, you have to provide notice And typically it's 14 days as we discussed. But when you're doing the elections, you have two requirements as far as timing is concerned for your condominium elections, and that's by statute. If you're in a homeowners association, you're going to go by what's in the bylaws. So the condos have a higher standard than the HOAs as far as elections are concerned. So again, your first notice is going to go out 60 days before the meeting. And that is the initial notice that you're going to send to the members and say, our annual meeting is in 60 days. We're going to have elections. Enclosed, please find an intent to run. If you want to be on the board, please submit it by this date. Okay. One thing to remember, if you don't receive an intent to run 40 days before the meeting, they have blown the timeline. Okay. So they have to produce their intent to run or notify the intent that they want to be on the board. It has to be done 40 days before the meeting. If not, they've blown the deadline. Then the second notice is sent 14 to 34 days before the meeting. Okay. When you send out the second notice, you're actually going to submit the ballots, the proxies, because the ballots are going to have the candidates on there who submitted their intent to run for condo associations. For HOAs, it could be a little different because you may be able to make nominations from the floor, okay? And then you have write-ins on the ballot as well for HOAs. So there are a lot of differences between HOA and condo elections, but when in doubt, look at your documents. I guarantee you will probably have a higher standard to reach than what's in the statute because the documents have probably not been amended or they're very old. Proxy voting. So if you can't attend a meeting, the members can attend by proxy, okay? And the proxy is valid for 90 days. And when you're trying to do an amendment to your declaration, the proxies will actually have the vote on it as to the amendments are concerned, and those proxies are good. So what happens is that if you have your meeting, let's say February 1st, but you didn't have a quorum, okay, your proxies are good for 90 days. So you can continue that meeting to a future date to get a quorum, and if you still haven't reached the requirement of the percentages that are in the declaration for an amendment, you can continue the meeting as many times as you need to within that 90-day period. The 90-day period starts to run the date of the first meeting, okay? So let's say, for example, Chuck, perfect example, we did this in your community. Huge amendment, big community. We had to continue the meeting several times. People went door to door, filled out the proxies, and we got it done. Very difficult task. But that's when you want to use this 90-day window with your proxies so that you can get those votes. And a lot of board members don't know that, okay? Next slide. Elections. Okay, again, do we have a question? Okay. Balloting required where there's 2 or more eligible candidates for a vacancy. So let's say, for example, you have in your bylaws the requirement to have 3 directors. And only 2 people submit their notice of intent. You don't have to have an election. Those 2 people will automatically be on the board, and then they can appoint a 3rd person if a volunteer doesn't want to stand up at the meeting and say, sure, I'll run, or I'll be on the board. So as far as the ballots are concerned, there's no write-ins, which is totally different for HOAs, okay? And remember, that's because they have to submit their notice of intent 40 days before the meeting if they're a condo. The condominiums also require secret balloting, okay? So you're gonna have an inner and an outer envelope in the package for condo associations because you're gonna submit all that information in the 2 envelopes. And the first envelope is just to check that you are an owner, that you've signed everything you're supposed to sign, you got your property address on it. And then that proxy goes into the count, but you don't know you know, you have to, excuse me, not the proxy, the ballot. You don't know who signed the ballot. You don't know where it's from. It's just the ballot, and that's what you're counting as far as the board member tally. You also have to have an impartial committee assigned to handle the election ballots. As board members, I recommend don't do anything with the election. Stay away from it. If you're running, don't count ballots. Don't be a part of it. Okay. When I do go to an annual meeting and we're having an election, the first thing I will do is ask the homeowners, can I get 3 volunteers to help us count ballots? Okay. And I'll go in the room, they will count all the ballots, we will check each other's work, and there, you've had your impartial committee. If you're in an HOA, your election is required if there are 2 or more candidates, then vacancies and the nomination from the floor is not required. Election disputes are submitted to binding arbitration, or they can be filed in court. The DVPR actually has jurisdiction over the dispute of elections, and the condo elections may have term limits per the statute. So you can't serve 8 consecutive years, okay? So let's say, for example, that your bylaws say you have 2-year staggered terms. Well, if you've been on the board already for 3 years, at 2, 4, 6, that's 6 years continuously. If you're re-elected for a 4th term, you can't run again. You have to take a break unless there's not enough candidates running for the board. So if you don't have enough candidates running for the board, okay, then the board will roll over, or whoever's submitted their notice of intent will automatically be on the board. Next slide. Okay, so the new law establishes certain fraudulent voting activities, and it constitutes a 1st-degree misdemeanor. Again, the voting fraud and the statutes changed dramatically because there's been a problem with that. You're preventing a member from voting as they intended, or you fraudulently changed or attempted to change a ballot, envelope, vote, or voting certificate. Now, it may not be on purpose, like Michelle said. You know, it could be innocent. Maybe you're filling in the date, or you're just writing in their unit number. You can't do that. The statute and the Florida Administrative Code are very specific that you cannot. If they don't sign it, if they don't put their unit number on it, you discard it. You can't change that ballot, even if you're just trying to help. You can't use any menacing or threatening, a unit owner using bribe or any attempt to deceive or deter a member from voting. You can't give a promise for anything of value, kickbacks, and using or threatening force, intimidation, or violence to get someone to vote a certain way. Meeting minutes. Remember, it's not a transcript. I've gotten meeting minutes that are literally 3 to 4 pages long. Don't have to do that. Just do bullet points. This motion came up. These board members voted. Da, da, da. You don't have to provide a dialogue of what everybody said. Just, you know, keep it simple so that you get what happened at the meeting, who voted, and what was the outcome of the vote. Okay? Also, you want to make sure that you permanently retain those records for 7 years. There are some official records that need to be kept indefinitely, and we'll go through that. However, the HOA documents have to be maintained for 7 years, and the condos have to maintain them permanently. In your meeting minutes, you want to list out what type of meeting it is, the date, time, and location that it took place, who's chairing the meeting. It may be the president of the association, who's present and who's absent, whether a quorum has been established, any actions or actions that haven't been taken should also. So let's say, for example, that you have a project, you're evaluating bids, and the board meeting was actually called to vote on which contractor you're going to use. Well, Let's say, for example, before the meeting, the manager says, hey, I got 2 more proposals, so let's table this issue. So you want to make sure that that's reflected in the minutes, that we didn't vote on this because we got 2 more bids and we're still going to consider this, so let's table this issue until the next meeting. Okay, financial responsibilities. And I'm going to turn it over to Michelle because she loves to talk about insurance.
We're talking about money. And just backing up on a couple of things, as Nikki pointed out, your minutes should be short and sweet, just the votes taken. They shouldn't be too long. And remember, one of the reasons for that is that you guys have to approve those minutes. It's your job as the board to approve the minutes at the following meeting. So if you've got 4 pages of minutes, that's a lot to approve, and it's a lot to remember. Well, did so-and-so really say that? Did that really happen? You really don't need that in the minutes, and it creates more problems than it solves. The other thing I wanted to highlight too is the new legislation is requiring when you do your board meeting notices that you post the meeting notice with an agenda and a copy of any contracts that you're going to be voting on. They are allowing you to do that on a website, and there's sort of a movement towards expanding the use of websites. So if you don't have a website, you might want to look at getting one. It was required in condominiums. The requirement is expanded from condominiums with 100 or more units to condominiums with 25 or more, and is now expanded to HOAs. So HOAs are going to be required to have websites too, and you can post your meeting notices on those, the contracts and documents that you're going to be voting on, and of course your official records, which we'll talk about. But I did want to say, so we're going to get into a new topic, financial duties. We've been going for a little while. Do you want to take a 5-minute break? Would that be okay for everybody? I mean, I can keep talking about this stuff for days. Let's keep going. But it looks like we need some. Yeah.
Sounds good.
Yeah.
Okay.
All right, guys, we're gonna get started again. So we're moving along pretty quickly. We've got a little bit more to do, and then we'll get to some questions. Our next topic for today, we're gonna talk about financial duties. So that's one of the most interesting issues for everybody, is they want to talk about finances. Annual budget. So one of the big responsibilities of any association is to adopt your annual budget. You obviously have some help with that. You have your historical budgets every year, and then your management company will assist you in preparing that annual budget. But you want to address all of the expenses of the association. Obviously your maintenance costs, management, contractors, landscaping, insurance, taxes, if you have any. You shouldn't have too much in the way of taxes. Utilities obviously are a big expense. Reserves, we will talk lots about reserves. Your revenues are going to be your assessments, for by and large, the assessments to the owners. You may have some other insurance proceeds, interest income, fining, things like that, that you will consider as revenues, but by and large it's going to be your assessments. Okay, so reserves. Big part of your budget is reserves. If you're in a condominium, this has been just a great and wonderful thing for condominiums. They went from being able to really determine their reserves annually to the legislature telling them that they have to reserve everything all the time. And so that is starting to take effect with the Structural Integrity Reserve Study. So if you're in a homeowners association, you're not required to have reserves, but we do recommend it. And so a reserve study, these are engineering companies typically that are in the business of creating these reserve studies. They will come out, they will look at your property, they will inspect your roads and your clubhouses and your pools and your drainage structures, and they will give you a schedule, a 30-year schedule of maintenance of all of those facilities, and how much you need to be reserving every year so that you are able to pay for all of the deferred maintenance, repair, replacement costs that are projected to happen over the next 30 years. Most of the time you can contract with them to update that every couple of years. Obviously it's a projection. And so, you know, as we've seen labor costs increase, materials costs increase. And so it, you know, it does change from time to time. So in a condominium association, you're required to do that reserving. You've always been required to reserve in a condominium for painting, paving, and roofing, and deferred expenses of $10,000 or more. That has now expanded with the structural integrity reserve study. So you not only need to have that reserve study done, and you should have had it done already. If you haven't, you need to get on it right away. There are a few communities that are entering the 30 years and have to do what's called a milestone inspection, which is a little bit more of an advanced type of structural integrity study. And they have a little bit of additional time to do their structural integrity reserve study at the same time as the milestone inspection. But otherwise, if you're not at that 30 years, if you have not done what we call the SIRS, Structural Integrity Reserve Study, you need to get on it. Any budget that is adopted going forward, so it was after December 31st of 2024, so where we're at now, anytime in a condominium association you adopt a budget, you need to fully fund your SIRS reserve. And previously, condominiums could waive or reduce funding of reserves. They can no longer do that with the SIRS reserve. In an HOA, you can adopt reserves and you can have your reserve study, and you can choose from year to year and say, you know what, this year we had a big insurance increase or we had some maintenance projects, so we're not going to fully fund our reserves. We're going to partially fund them, or we're going to skip this year and catch up next year. You can't do that in a condominium, not with your structural integrity reserves. So we'll talk about that a little bit. Let's see. If a condominium is supposed to waive. Yeah, so it used to be that you could waive or reduce reserves, and then you would have to put that in your notice that if you're waiving or reducing reserves, your community could be subject to a special assessment. Because what communities did do in the past, and some of them elected to do this intentionally, is that they said, well, instead of reserving every year, we know that in 5 years we're going to need to do painting. We're fine with doing a special assessment. We as a community think, you know what, instead of putting money in a fund and paying into that and having it sit there, we'd rather keep our money. And then when the 5 years comes and it's time to do the painting, we'll pay our $10,000 or $5,000 special assessment, and we're good to go with that. And that was just something the legislature also required you to notify folks if you were not going to reserve, that you were looking at potential special assessments in the future. Now, in a condominium, you have to fully fund those SIRS reserves. You could have what we call non-SIRS reserves, which are anything that is not part of your building. So the SIRS is the structural integrity of your condominium building with the units in it. If you have a separate pool or you have roads, those may not be under the SIRS, and you could you have to reserve for them, but you might be able to waive and reduce funding on those things. Next slide. Okay, just a little bit more about the SIRS. It's condominiums of 3 stories or more. I actually had somebody last night that suggested that I live in a townhome community, and they're like, well, we might have to be subject to the SIRS sometime in the future because we have 3-story townhomes. And I'm like, no, for a townhome, if you're a townhome and you're under an HOA structure, you do not need to worry about SIRS. Could the legislature change it sometime in the future? Possibly. I don't see that happening anytime soon, because the condominium is such a different type of structure than a homeowners association and a single family or even a townhome. Condominiums, we call them houses in the sky, because you have a unit on top of a unit next to a unit on top of the unit. And so there's more legislative oversight of condominiums because they are creatures of statute. If you did not have a statute that permitted condominiums, you couldn't have them. But you know, all in history, we've had property with houses built on it. So HOAs are a little bit different. So the condominiums have gotten this additional regulation. And so the SIRS, these are some of the components of the SIRS reserve. obviously your roof, your building structure, the walls, plumbing, electrical systems, waterproofing and painting, fireproofing, windows and doors. There's a lot of your condominium declaration is going to talk about who's responsible for maintaining some of these items. Windows and doors has come up, windows in particularly recently, and the question is, you know, does my declaration of condominium say that that's part of the unit, or is it a limited common element? Or if it's part of the unit, is it the association's responsibility? Because typically, if you have a high-rise condominium, we don't want the unit owners hanging on the exterior of the 12th floor trying to replace or clean windows. That's usually an association responsibility. But there are some condominiums, especially smaller ones, where maintaining the windows, replacing and repairing them is an owner responsibility. But now we have the SERS that says that you're supposed to be reserving for that. So if those issues come up, you want to look at what your declaration says, and then also what the SERS requirement is, and try to reconcile those. Okay, insurance. So this is obviously part of your fiduciary duty to your community. You need to insure your property. You need to have property insurance, liability insurance. You need that director and officer liability insurance to protect you all as directors and officers. And you need to have a fidelity bond. And the fidelity bond protects your bank accounts. So the amount of the fidelity bond should be consistent with the amount of money that you will have in your bank accounts during that insurance year. We've seen people with hundreds of thousands of dollars in reserve, and they have a $50,000 fidelity bond. Well, if there was some theft or something of your funds, you're not covered. So make sure that fidelity bond matches how much money you have. There are other types of insurance coming up. You all should have an insurance agent, and you can invite them to come to your meeting. They will come, and they're happy to talk to you about different types of insurance products. Cybersecurity insurance is something that's become very popular. I've heard people talk about volunteer insurance because I have some, usually HOA communities where they want to get volunteers together to do certain projects. They want to clean up the landscaping or the entrance sign. They want volunteers to do that. As lawyers, we always see the bad things that might happen. So we don't really encourage having volunteers do work for the association because we see the trip and falls that are going to happen, or somebody getting bit by a snake or something like that. But if you don't ask your lawyer and you go ahead and do it, you do want to make sure you have some sort of volunteer insurance coverage. I'm sure if you're in a condominium, you've seen your insurance rates spike. And yes, spike is like escalate like that. Good news, sort of, I think. I heard a rumor from an insurance agent that they do not predict any significant increases this year, notwithstanding the 2 hurricanes, because apparently the one hurricane, Helene, was more of a flood issue, which did not affect your insurance as much. And then Milton, the way it was explained to me, the damages that occurred in Milton were consistent with the actuarial tables or whatever it is the insurance company uses to predict loss. And so they're not foreseeing a dramatic increase. Don't hold me to that because it's not my area of expertise, but I did hear that. And so I just wanted to let you all know, potentially you might not see any huge increases this year. So hopefully that is correct. Okay, so financial reporting. You have a financial reporting obligation to your owners. You have to do an annual financial report. There's an audit. If you're an accountant, you're familiar with these different levels of accounting, but you can do an audit, a review, a compilation, or a report of cash receipts. And it depends on the revenues of your association. So if you're $500,000 or more, you have to do an audit. We do encourage folks, even if you're below that, you might want to look at doing an audit. It is more expensive, but it's a more thorough analysis of your financial records, and it protects you as a board from allegations of any wrongdoing. You can say, look, I know you're saying that I filtered money or whatever because I, bought a new Toyota, but in fact, you know, we've had an independent auditor review our books every year and the audit is clean. So you don't have to do that if your revenues obviously are lower. And even if you're required to do an audit and you're like, oh, you don't want to spend the $5,000 this year to get an audit, could we just do a review? You could do that with a vote of the members. It's a majority of members at a meeting, but you can only do it in non-consecutive years. So it used to be you could vote every year to waive the audit requirement. You can only do it in non-consecutive years now. Okay, assessments. So that is the unit owner's obligation. They have to pay assessments, obviously the schedule of assessments, and the amount is typically determined by the board. The board adopts the budget and adopts the assessment. I have seen some covenants that require member approval of the budget. We try to write that out if we can and amend your documents to remove that. It really should be the board adopting the budget because you are the most dialed into the financial needs of the community and the costs. And by statute, there's no statutory requirement for member involvement in budget. So I would, you would want your documents and your association to be consistent with that. And then the board can determine the schedule of assessments. In an HOA, you can have them as infrequently as once a year. In a condominium, they have to be at least quarterly. And we've seen a lot of increases in assessments. So let's see what else. Your lien right. So this is obviously your most important right. And if there are any financial obligations of an owner to the association, incorporating them in that lien right is the easiest way to be able to ensure that you can collect that money. We have seen some changes in the statute that added a new notice requirement. So if an owner is delinquent in assessments, our recommendation is that you want to have a collection policy and you want to stick to your collection policy. You do not want to be giving different treatment to different owners because that could be seen as a breach of your fiduciary duty. Are you being kinder to this person because they're your neighbor or they're a relative of a relative or they're a close friend? You want to have a consistent policy. They mentioned this is where you use your manager as the buffer. You are not individually making decisions. You're just following your policy. So it does take a certain amount of time to enforce collections, particularly in a condominium association when your monthly or quarterly assessment is a little bit higher. You want to stay on top of non-payment of assessments because the further that people get behind, the more quickly that receivable increases, the harder it is to collect, right? It's easier to collect a couple $100. It's a lot harder to collect $10,000, $15,000. And we have seen it. We see it all the time. We see associations going back to like 2018. You got, delinquency that's 6-7 years old. And that's a lot of money to collect. And let me tell you, if this person has not been paying their assessments to the association that they live in, they're not paying other people as well. And so you're running into a lot of problems. But if you stay on top of it and you move quickly, you're more able to collect those assessments. And remember, the assessments are not just the obligation of the owner, they're the obligation of the property, because that property receives the benefits of the association. So the obligation is owed by the property. So in terms of your procedure, you want to send, it's called a notice of late assessment. Your management company will send that notice. You have to do that prior to referring it to an attorney for collections. They have 30 days to respond to that notice. And then if they don't respond, then there's a notice of intent to lien. They have 45 days to respond to that. If they don't, then there's a lien placed on the property. And then you have to send them another notice of intent to foreclose, and they have another 45 days to pay. And so, as you can see, you're looking at 120 days from the first notice before you could get to a foreclosure. And even that, there's a little bit obviously of timing in between that. So from your first notice to even filing a foreclosure lawsuit, you're looking at 5 or 6 months typically. That's a lot of time for the owners to work the problem out. And so we really do see a lot of these collection matters get resolved before it goes to a lawsuit, and certainly before it goes to the sale of property. So I know a lot of people are concerned and they're like, well, I know, this owner's had some issues. Do I really want to send them to collections? Yes, you do. It is part of your fiduciary obligation. It's not the most fun part, but it is part of it. If somebody's not paying their share, that gets deferred on to the other owners to pay. So, go ahead and start sending those notices, because that makes sure that the owner's aware of the issue. Sometimes they're not aware of it. Sometimes there's issues with the payment. They changed bank accounts and it's not getting pulled from the bank, or the management company had to change bank accounts. So you want to make sure that there's not an issue that's causing that. And then if they're having a financial, problem, sometimes there's ways to work those things out. But you won't really get to that until you start this process. So that is your main way of collecting assessments. You do have other options if somebody's not paying their assessments. You can suspend their right to use the facilities, the common areas, pools, things like that. And you can also suspend voting rights. Intercepting rent from tenants. So this was a thing years ago. I don't see it happen that much anymore, but every now and then people will say, well, owner A is not paying their assessments, but they've got a tenant in there and I know they're collecting rent from the tenant. Can we intercept the rent from the tenant? And there's a statute that permits that. We've kind of gravitated away from that practice and have not really used it in quite a while. Part of it is because it conflicts with the Fair Debt Collection Practices Act, or it could potentially conflict, in that you really shouldn't be disclosing a debt to somebody other than the debtor. And are you kind of disclosing it to the tenant? There's that issue that we don't want to run into. And it really is, if you send those letters and you enforce collection of the assessments by that legal process, that to me is the more effective way to do that than going through the tenant. So, and honestly, a lot of times I see it as people wanting to get rid of problem tenants more so than just collecting the assessments. So, you use your legal process.
I have a quick question. If you have owners that are getting behind in their monthly HOA dues and they live overseas, is there any legal ramifications to getting that money from them?
If they live overseas, then they're not military. So if they're in the
Right.
military, there are some protections for military folks, because understandably they're serving the country. So we want to be a little bit respectful of that. And but if somebody owns, that's a good question. If I own property in Tampa, Florida, in Hillsborough County, and I live in Sweden somewhere, and,
You know that's where he lives. You got it. Go ahead. Sorry.
it's one of the happiest countries. Isn't it? So I don't have to pay my assessment. I'm far away. So yes, they still have to pay. If you have the address for where they're at, we do have to send the notices to that address. And if they don't respond, you can still proceed with the full collection practice.
Right.
And we do see that. We have plenty of people overseas that are delinquent in assessments. But again, remember, there's all of those notices that are going to go to them before you get to a lawsuit. And that'll give them plenty of opportunities to remedy the delinquency if it's just an oversight, if they weren't getting their mail or for whatever reason. But yeah, you can still collect on those. As I mentioned, if somebody's delinquent in their assessments, they may have other financial issues, mortgage foreclosures, bankruptcies. Those will not necessarily prevent you from collecting assessments. Bankruptcy in particular will slow things down because once somebody files for bankruptcy, there's what's called an automatic stay, and you as a creditor, your association as a creditor of that person, you cannot continue to directly pursue them. your collection has to go through the bankruptcy court and will be regulated by the bankruptcy plan, as long as they continue in that bankruptcy. And then mortgage foreclosures, at a mortgage foreclosure sale, if they get to a sale before you, you would only recover 1% of the mortgage for 1 year of assessments, whichever is less, I think. And so if somebody is in mortgage foreclosure, there is a potential that you would not be able to collect the full amount that is due to the association. We don't see that happening as much anymore as it was happening years ago. But something to be aware of, and that's why I say stay ahead of it, because we can be more nimble and move faster with a collection lawsuit. The mortgage one foreclosures take a little bit longer. So next slide. Violations. All right, well, I'll let Nikki talk about violations. Those are our non-monetary violations of your governing documents.
Okay, so the law has changed a lot in terms of violations. They're actually restricting associations from preventing owners from doing things on their property. And again, as Michelle indicated, these are non-monetary enforcement issues. So when you're enforcing the rules and regulations of the association, as Michelle indicated, create a policy. Our firm actually has a corporate package that we create for all of our clients, and it encompasses various policies. You have your collection policy, you have a board meeting policy on recording and things like that. So it's very important that you set the standard with these resolutions and policies, and send notice to everyone. So either management or the association is going to contact an owner through a letter stating you're in violation of article whatever of the declaration. And in addition to that, you also have the power to fine homeowners. Condo associations I don't like the fining for condo associations, only because you don't have any teeth to enforce it. HOAs are different. HOA fines can become a lien if they are in excess of $1,000. So when you're dealing with these type of violations, you want to try and use those powers that either association may have to enforce the covenants, and fining would be a way to do it. However, for a condo association, you don't have lien rights, so you can't really collect it unless they pay you or you take them to small claims court. So if you're going to collect that fine, it would be listed on the estoppel when the property is being sold, and then they would collect it then. You also have abatement, and this is very critical. Our firm, all of our attorneys have had this experience where we'll file a lawsuit for a violation of the governing documents, and we get to the summary judgment hearing, and the judge says, well, did you have an obligation to try and correct it? And if you look at the governing documents, it'll say that if a homeowner does not comply with the rules, that the association has a right to go onto their property, correct the violation, and then whatever it costs the association will become an assessment on their ledger. If you have that language, you must attempt to rectify the violation. I had a case where the defendant homeowner didn't even respond to the complaint, never showed up to the case. I go to the final hearing and I'm like, nobody's here, judge is gonna give me my judgment. The judge asked me, do you have abatement rights? And even cited to a case that came out 2 years ago. The association is under an obligation. Now, if you only have to attempt. So if you attempt it and the homeowner comes out yelling and screaming, don't you dare come on my property. Great. Now we have an avenue to go to court because we need to ask the judge for an injunction to have them repair their roof, or to cut their lawn, or to remove any type of items that are prohibited off the lot. So it's very, very important that you look at that, because it's changed our practice too. We are actually requiring certain documents from the association before we'll even step foot in court. Okay, so we're doing our due diligence to get you guys to comply with the governing documents, so that if we go to court, it's not going to be a loss because the association didn't take steps to try and correct the violation first. Okay. So however this process starts, normally management will send out a violation notice. Violation notice has to list what specific article in the declaration has been violated and requesting them to correct that violation. If they do not comply, then the matter would get transferred to the attorney, and we would send a pre-suit mediation letter. That letter is required to be sent out to try and resolve the issue before you step into court, okay? If a homeowner fails to respond to the pre-suit mediation letter, they've waived their right to collect attorney's fees if we do go to court and they win, okay? If the homeowner responds, you will go to mediation. Try to resolve your differences or the violation. And if it's an impasse, meaning you don't come up with an agreement to cure the violation, now you can go to court, okay? But unless you have that step first, if the association skips this step or files suit too soon, before the pre-suit mediation letter expires, then the associations waive their right to attorney's fees, okay? So these pre-suit mediation requirements are there to help you stay out of court, okay? Do the pre-suit mediation letter, come to the table with the homeowner and resolve what's going on, if you can. If you've got a crazy homeowner that just doesn't want to comply and they're going to do what they want to do, great. All right, we'll let the lawyers handle it. Okay. Fining. So fining is, I find this to be complicated for the board, because a lot of times I will get a violation case and they have fined the homeowner. So the first question I ask management is, can I have a copy of the fining hearing notice? Okay. And they're like, well, they didn't send a notice. And I said, okay, well, if you haven't sent the notice that there's a hearing in front of the committee, then you can't fine them, okay? And I've even had boards just go ahead and issue a fine. Okay, we're gonna fine you $1,000 because you haven't cut your grass. You can't do that, you know? And I had to revert several fines that were on ledgers because the board didn't go through the process of first having a meeting, deciding to fine the homeowner for the violation, okay? Once the board makes that vote, then it goes to the committee, and the committee has to be at least 3 disinterested homeowners or your manager, and they sit in front of the homeowner, who is allowed to bring an attorney, okay, to a fining hearing. And the fining hearing is basically speak to the owner and say, what are you doing to correct this violation? And I usually tell my committees, if they're fixing it, in the process of fixing it, waive the fine. You know, I mean, why not? And at that juncture as well, you may enter into a settlement agreement, okay? And that's for the lawyers to draft. But in any event, you have to follow these procedures. Now, within 7 days of the meeting, the association has to send notice to the owner stating whether the fine was upheld or rejected. And remember, only the committee can make that determination, not the board. So if the board levies the fine, they have the hearing in front of the committee, the homeowner has cured the violation, then the committee will rule and say, they cured the violation, we're going to reject the fine that the board approved, okay? So the notice has to be sent within 7 days of the hearing, and it also has to indicate what they need to do to cure the violation, and also the date which the fines have to be paid, which is not less than 30 days after they deliver the notice, okay? And again, as I indicated, also, you cannot fine for garbage cans being out anymore. The new laws regarding what you can store on your property have changed. So if you have garbage bins that are being left out 24 hours before or after pickup, and also leaving any holiday decorations up, unless the decorations are left longer than 1 week after notice of violation has been sent to the owners. Okay, let's talk about official records. So I had previously hinted on the hierarchy of documents and what each one stands for. Again, there are new requirements where condos and HOAs have to maintain their records for a certain amount of time. Condominium associations have to keep their records indefinitely. And we look to see what actually encompasses the definition of an official record. Okay, so the official records are open to inspection by all of the members, okay? And the board has 10 days to respond to an official records request, or there's a presumption that you willfully denied a unit owner or a homeowner from inspecting records, and the DBPR can sanction the association with very heavy fines. So once you get that notice, and for my managers too in here, if you get that notice for a records inspection, you gotta be on that quick, because you get 10 days to make those records available for the homeowner to inspect, and they can copy them too. So what are the official records? They're the original declaration, bylaws, articles of incorporation, rules and regulations, and all of the amendments to those documents that have been recorded over the years. In addition to that, your meeting minutes, voting records for either your elections and also for your amendment votes, okay? Remember that your election is only valid, you only have to keep them for 1 year, because if you don't file a lawsuit or a complaint within a certain period of time, you've waived your right to pursue any type of election disputes. Financial and accounting records. This now includes invoices, receipts, and deposit slips. So before you didn't have to have that stuff, now you do. And you have to keep track of the money that's being spent and by who and for what purpose. Building permits, record inspection checklist. This is new, that came out last year. So I have seen a lot of law firms who represent other associations. What they've done is they say, okay, you have a records request. Here's 6 boxes. You can't do that anymore. Now what you have to do is create a checklist. And the checklist, you have to respond to every single request. Do you have this document? We have this document. If you don't have the document, you have to state why you don't have the document, okay? So the checklist is critical, and this is new per the statute. So we've actually seen a lot of attorneys not comply with this new law. And they're supposedly condo and HOA lawyers, but no checklist when we ask for an official records request. Okay, records must be provided within 10 days, as I indicated previously, and the records must be maintained in an organized manner to facilitate owner inspection. A good faith effort is required to recover any missing, lost, or destroyed documents. And I know everybody who's a board member knows when you switch hands or switch management companies, some of those records are lost, you can't find them. So just remember that you do have a fiduciary duty to know where those documents are and maintain those documents. And there may be a provision in your management agreement that requires that the management company maintain those official records of the association. Renters may inspect and copy only the declaration, bylaws, and the rules. Okay, they don't have the right to financial information or any of that stuff because they're not a homeowner. They don't pay assessments. They just need to comply with the governing documents, whatever rules and regulations are contained therein. You can also impose rules for inspection and copying. How many managers have had that homeowner that wants to inspect records every single month, or every 3 weeks, or every 2 weeks? You can prevent that. The board needs to implement a policy regarding inspection of records, okay? You can limit the inspection of records once a month, once a quarter, and things of that nature. So you can implement a policy that will deter that nuisance. And I know that it is very time consuming as well for managers because they have to collect all of these documents and present them to the homeowner so that they can inspect them. It's not just putting boxes in front of these people so that they can sift through it. Okay. Confidential records that are not considered official records are any opinions or attorney-client privilege communication with the association's attorney. Any personnel records for your employees, you're going to have social security numbers on there, their address, and those type of things. We're talking salaries, not in official records. I previously indicated possible medical records are produced for reasonable accommodation to have a dog in the community. Electronic security passwords, whatever software you guys use, those username and passwords are not considered official records. Other protected member information, social security numbers, driver's license, credit card numbers, email addresses, fax numbers, emergency contact info, or other addresses and personal information, and any information that's obtained from a gated community, okay? And this would include the list of visitors to parcel owners. So that too. Non-protected member information, your name, unit number, mailing address, property address, telephone number, email, and fax info provided for notice requirements. The emails may only be used by the association for notice purposes if they have signed, physically signed a wet signature saying, I opted for electronic notices. So if the homeowner has provided you with that written authorization, you don't have to mail notices to them anymore. You can send it to them by email. Now they can revoke that, and then you would have to submit the paper copies in the mail or whatever other form your declaration or bylaws provides for notices. Again, anybody who is knowingly or willfully fails to disclose records per the statute or destroys records may constitute a misdemeanor, or to avoid detection, punishment for a crime may constitute a felony. So the laws are becoming a lot more stringent as far as these official records are concerned. The DBPR is inundated with complaints against home associations because of this very issue. Any director, member, or association manager who knowingly, willfully, and repeatedly violates records inspection laws with the intent of causing harm to the association or its members commits a misdemeanor of the second degree, and repeatedly means 2 or more violations within a 12-month period. Additionally, any person who knowingly or intentionally defaces or destroys accounting records also is subject to a misdemeanor in the first degree. And is subject to a civil penalty and has to be removed from office, okay? And this would be one of the eligibility factors when people are running for the board. So this is also one thing you want to check on. The willful and knowingly refusing to produce records with the intent to avoid or escape detection. Again, that is a 3rd degree felony and it requires the removal from office. Okay, let's talk about the website and mobile apps. I love the website requirements. You know why? Put your documents on there. You'll have less record inspection requests. Everybody gets a username and password. They get on the website. Okay, I want to see the financials from last month. I want to see the annual report for last year, okay? They have that information at their fingertips and you don't need to produce records. If you do get a records request, your response is everything's on the website. Go to the website, okay? So websites are actually required for condominium associations who have 150 or more units. And in the HOAs, if you have 100 or more lots, you have to have the website. Even if you're a small community, it is strongly recommended that you do get a website so that you can post all these notices and official records of the association. The association may fulfill the records request by directing owners to the website and must have owner-only accessible page. Meeting notes, meeting minutes, records, and documents must be posted, include all the governing documents, the rules and regulations, your management agreements, your summary of bids. That was not a requirement before. You have to keep all of them now. All of the bids that you receive are now considered official records, not just the guy that you contracted with. Your annual budget, your proposed budget, your financial reports, your certifications for taking this class are now required and are considered an official record of the association. And contracts and documents involving any interested director or community association or manager, all your notices and your agendas for membership meetings and your board meetings, bids received within the last year, all your insurance policies, and your current contracts that the association is a party to. So I'm going to let Michelle talk about these miscellaneous regulations. There's a lot of different federal regulations that overlap with state.
So, just, with respect to the websites, I mean, we're definitely seeing some movement in the legislation slow, but movement towards using websites and electronic means of communication. So we've been very behind the times in HOAs and condos and having to mail everything and do things that way. But we saw more of the shift toward the websites. And if you don't have one, as Nikki said, you really want to look at having that website. So it will make your lives a lot easier responding to those official records requests, especially with the repeat requests that we get from folks. It will be very helpful. Okay, moving on. So we're pretty close to finishing up with the slides, and then we can take some questions at the end. But we've got a few things to wrap up. So these are miscellaneous regulations. So the Fair Housing Act and the ADA, these are other legislation that would apply to an association. Usually the ADA does not apply to a condominium or a homeowners association. ADA applies to places of a public accommodation, which you typically are not unless you're opening your clubhouse to non-residents or something like that. But typically it wouldn't. So the Fair Housing Act, though, does apply. And so you may have to make a reasonable accommodation for somebody with a disability. This can be modifications like handicap ramps if you don't already have them. And then everybody's favorite, the emotional support animal. So we see a lot of these, and it is very interesting. Your obligation as a board is simply to ensure that they meet the requirements of the statute, and that the emotional support animal is there to assist them with, permitting them to live in their property. They have a disability, and this is something that is going to facilitate them in their daily life activities. We've seen emotional support chickens, emotional support ferrets, dogs obviously very much, but there's yes, the chickens and the ferrets are a little bit of a surprise. And listen, it's not your job to vet out whether people are being truthful or not. You just want to make sure that they have provided the documentation that allows them to have that pet, and that if they don't, that they're not permitted to keep it. I did actually have emotional support ferrets, and we were able to, and they were denied, these were renters, and they wanted to have their 5 emotional support ferrets, and they were denied, and they filed a fair housing complaint. We did prevail on the complaint, but I will tell you it was very expensive. And there's no way for the association to recover its money if you prevail on a fair housing complaint. It's just not, there's not a mechanism to do that in the statute. So when you have these requests for accommodations, you really want to get your legal counsel involved right away and see if you can resolve it and avoid that fair housing complaint. Because even if they have no leg to stand on, it's going to cost you time and money to respond to that. There are other regulations that apply to your association. The Federal Communications Commission, FCC regulations on satellite dishes. Folks can have satellite dishes. You can make recommendations on where they put them. If you're in an HOA, what part of the roof. If you're in a condominium, they cannot attach them to the common elements. And so otherwise, there's really not too much you can do. You cannot require them to put the satellite dish somewhere that will compromise the signal. So I don't know how many people have satellite dishes still, but it is in the statutes. Golf carts, a lot of HOA communities allow golf carts. You used to be able to have 16-year-olds without, or even 14-year-olds without driver's licenses, which was probably really fun for those guys. But now you have to have a driver's license or be 18 in order to operate a golf cart. And that's on public roads, but we've, obviously recommended if you have HOA community roads that you adopt the same regulation. I talked briefly about the milestone inspection. This is a structural inspection of a condominium building. Again, 3 stories or more, similar to our SERS. And it looks at structural members and systems of the building to make sure that it's structurally sound. Obviously, the statute came right out of Surfside when that condominium collapsed. Obviously, there was a lot of attention to the structural integrity of our condominium building. So every 30 years, you need to have this milestone inspection. And the local building officials are supposed to get involved. They're supposed to send you a notice that you're due for it. And you have a certain amount of time to complete it. It's a 2-stage process. There's a first part of the study, and then if any issues are identified in that first visual inspection, you'll have to have the second stage of the study. You will need an engineer to do that for you. So there's a little bit of a cost. And if the building official, there are some communities where you might need it sooner. If you're particularly close to the water or some reason like that, you might need to have it at 25 years instead of 30 years. But that building official should send you that notice to let you know when you're due for it. Next. Okay, energy conservation and renewable resources. I love this slide because I love trees, but might be the only one. But there are statutes that are geared towards energy conservation issues. You cannot prohibit people from having clotheslines. If somebody wants to have a clothesline in their backyard, they can have it. You can kind of enforce the wear on the clothesline as long as it's not visible from the front or a neighboring parcel. Solar collectors and solar panels. If you're in an HOA or a townhome, if somebody wants to put solar panels up, they can do that. You cannot prohibit them. You can encourage particular placements. I think it's something about the east and the south side of the house is where they function best, and so you couldn't prohibit them from doing that. But wherever you can't interfere with their functionality. But otherwise, you can make recommendations on where to put them and the types, but you certainly cannot prohibit them. In a condominium, you can have electric vehicle charging stations, and that would not be a material alteration of the common elements. If an owner wants to install that is at their expense, or the condominium could install them for all the owners if they wanted to have several as part of the common elements parking, and again, it would not be a material alteration. If somebody wants to have Florida-friendly landscaping, I guess in an HOA more so obviously than a condominium, there are statutes that protect owners' ability to have that. And so there's some other suggestions for associations if you wanted to look at conserving resources. So turnover. So turnover applies when the developer turns over control of the association to the owners. If you're an established community, this statute is not going to be very interesting to you. But so turnover happens usually it's when roughly 90% of the units in the condominium or the HOA have been sold to individual owners. There are some stages before that where if there's 50%, you might have to have one owner on the board. Otherwise, while the developer is in control in building, obviously they operate the association and they put their developer appointed directors on that association. If you can, and we worked with developers who are going through the process of construction and getting towards turnover. And a lot of them want, to make this turnover clean. They want to turn over and they want to be done and be able to move on from the community. So a lot of times they will voluntarily allow community members to be on the board sooner than they're required to under the legislation. And that gives that owner some input and buy-in on what's going on in the community. But the important thing about turnover is as much as the developer wants a clean exit, it is not their final exit. So that is when the owners take control of the board, and that is when the statute of limitations on claims against the developer starts to run. So do not worry if you're not turned over, the developer's in control of the association, and you see problems with the construction or operation of something, your statute of limitations has not started to run until you do that turnover. So once you do the turnover, in a condominium, you'll get a turnover study. In a homeowners association, you may want to have an engineer do an inspection of your property. They can do it in conjunction with doing a reserve study, and they can let you know if there's any potential construction issues. And that is when you can start negotiating with the developer and or bringing claims if you need to. Okay, next one. We're on to MARTA. Oh, sorry. Yes, the Marketable Record Title Act. If you're in a condominium, do not worry. This does not apply to you. In a homeowners association, MARTA is very important. Very, very important. So what happens is in Florida, there's a legal presumption that we do not want covenants to apply to property unless that's what the owners want. So the MARTA says that after 30 years, covenants expire unless the owners take action to preserve those covenants. And it's supposed to promote the free use of land in the state. But what happened is that it started applying to homeowners associations, and your recorded covenants, those are restrictions on land, after 30 years, they went away. So that became a problem because you can no longer collect your assessments, you can no longer enforce restrictions on use of the property, maintenance obligations, all of that is gone. Your lien right is gone if you don't have it in your covenant. So if you are nearing 30 years, if you are at 20 years or more, preserve your covenants, because the board can do it. It's a preservation of your covenants. It's basically a one-page document, and we attach that to your existing covenants and we record it in the public records, and you're good for another 30 years. If you miss the 30-year window, you can revitalize. That is a much more difficult process. It involves the Department of Commerce, which used to be the Department of Economic Opportunity, has to approve your application. The application has to have member votes. There's notice requirements. It's expensive. It's time consuming, and it is not guaranteed. Preservation, simple and easy. So there's no requirement on how soon you can do it. So like I said, if you're at 20 years or more and you're in an HOA, I would go ahead and preserve it. Part of that is selfish, because if I'm the lawyer and my expectation is that I will not be practicing 30 years from now, so not going to be my problem. So if you do it now, I'll have to worry about it. But I literally have panic attacks looking at somebody's documents and doing the math wrong, and I'm like, oh my God, they missed the deadline. And they're like, oh wait, we have 10 more years. Okay, good thing lawyers are bad at math. But really pay attention to that, because that is very important. Okay, summary. So yeah, there we are. You guys know everything you need to know. You are ready to operate an association for at least the next 4 or 7 years.